Hello, I am Advocate Nikita Pandit and I will be speaking on Introduction to the Patents, and you are watching Legal Bytes. The main objective of this video is to understand what is a patent and what can and cannot be patented in India. Patent is a right which is lawfully given to the person to make and sell his invention for a certain period of time. The person who has the right is the sole person who can make or sell his invention within that given time. World Intellectual Property Organization explains patent as an exclusive right, which means right to the exclusion of all the other people other than the inventor. Such right is for a product or a process where there is some new way of doing something, or where the work offers some new technical solution to some problem which solution never existed before. Technical here means specialization in a field of study, usually in science and technology, where there is application of some practical know-how of that subject. Such invention should offer some solution to the technical problem in that field. WIPO explains patent right as an exclusive right which is given to the inventor to prevent the other people from making any gains from financially exploiting his invention by selling, distributing or using it without his permission. In India, patent rights are granted and dealt with by the Patents Act of 1970, which replaced the Indian Patents and Designs Act 1911 and all its amendments too. And this Patent Act was last amended in the year 2002. The central government was given the power by this statute in its section 159 to make all such rules which are necessary for giving force to this act and its provisions. Such rules were passed in the year 2003 and were last amended in 2020. Section 2 of the Patents Act defines what is a patent in a very general manner. It explains that patent is a patent granted by the Act for any invention. So let us see what is an invention. As per Section 2J, invention is any new product or a process which involves some inventive step and is capable of industrial application. According to Section 2JA, inventive step is that feature of an invention which involves some technical advancement, as we have seen earlier, which did not exist before, or economic importance, or both, such that it is non-obvious to the person who is skilled in the art. For example, a physicist or a mechanical engineer or physician are skilled in their professions in separate fields. Non-obvious means which cannot be easily discovered or understood by the person of that particular field. Another criteria that patent must be capable of industrial application is explained in Section 2, Clause AC. It should be such that it should be capable of being used in any industry. To understand the meaning of industry, we can see where the word appears in Indian law. It can be seen in Industrial Disputes Act 1947 in Section 2J, where industry is explained to be a systematic activity which is carried out as a result of relationship of workmen with their employer for the purpose of producing goods or supply or distribution. It also includes such activities in case of services where the main intention of all is to satisfy the human needs and wants. Now this act also mentions new invention in Section 2L. It means anything which is not yet anticipated before the date on which the patent application and complete specifications were filed. It should not be recorded by any publication or document before, whether in India or elsewhere. Invention to be new should be such that it has not fallen in public domain. That means it must not be known to the public, or it must not form a part of prior art. Section 3 and 4 of the Patents Act explain what can and cannot be patented. Now, as explained before, all the inventions can be patented provided they fulfill the before mentioned criteria, but this act provides specifically for what cannot be patented. First is frivolous inventions and the ones opposing the natural laws. They cannot be patented. Frivolous inventions means useless inventions which do not have that much use. Natural laws means the ones that are existing in nature, for example law of gravity or the law of night and day or magnetic forces. The inventions that may be contrary to the public order or morality or which cause harm and prejudice to humans, animals, plants or environment made for commercial exploitation is forbade from being patented. WIPO has given some examples of what is against public order or morality. For example, human cloning or modifying the genetic identity of humans or animals where suffering is caused to them. Basically, contrary to public order and morality means anything which hampers the regular working of the society and it affects the persons to act in regular and efficient manner. It affects them, they cannot act in the regular way. Discovery is not patentable in India. Whether a scientific principle or a theory or living or non-living substance, discovery is mere finding some information or something for the first time which was not known before. This means it already exists, it just becomes known to someone for the first time. Discovery of America or India or law of gravity are some examples. It also involves discovery of a substance which does not really enhance the known efficacy, that is the ability of it to produce a particular result. It cannot be patented. This is where a person only comes up with some new way of using something. However, if such use results in some new product or process where at least one new reactant is added, it can be patented. Just mixing the substances that combines the properties of the substances or any process for doing such combination is not patentable. Also, arranging, rearranging, copying the independent devices that can work independently of each other, which everybody knows cannot be patented. So, in short, any combination not resulting into something new is not patentable. The methods are not patentable, like agriculture methods such as for increasing the quantity of crops or for increasing their production, treatments to the seeds for betterment or otherwise. The examples of methods of agriculture are organic agriculture or conventional agriculture, crop rotation. Horticulture also involves plant and growing food which are usually high value, and there is the use of scientific methods in doing so, such as greenhouses. Now these cannot be patented. The processes for treatment of human beings or animals where their treatment is done from the diseases or their economic value is increased, such processes cannot be patented, such as medical process, surgical process, diagnosis, therapy and the likewise. The reason being that the Hippocratic Oath in medical field, it puts an obligations on these professionals to preserve and protect the life, and the purpose of the patent is giving economic benefits to the inventors. Merging both would hamper the public policy. Plants and animals, whether whole or in part, cannot be patented. This includes seeds, its varieties, species and biological processes for production and propagation of such plants, and also that of animals. However, microorganisms can be patented. Microorganisms are explained by science as the naturally formed decomposers, which means organisms that decay the material such as bacteria, viruses. Methods cannot be patented, like in maths, business, computer programs, algorithms, which means the method or set of rules used by the computer to solve the problems. Performance of mental acts of playing games. Also, mere presentation of information cannot be patented. Anything covered by copyrights and designs cannot be patented. Topography of integrated circuits cannot be patented. Topography means arrangement. Integrated circuit is where small electronic parts are assembled together and they are interconnected on semiconductor, and the resultant device is a small, usually it is a square chip. They are used in the computers like mobiles, amplifiers, timers, clocks, memory cards, sound chips, calculators and similar devices. An invention which is already in traditional knowledge or which only combines or duplicates the known properties is not patentable. Now, Section 4 of the Act prohibits granting of patent in anything related to atomic energy. This is as per Section 20 of the Atomic Energy Act 1962, and it includes the acts of mining, extraction, treatment, fabrication or likewise of such atomic energy leading to production, control or disposal. The same section has given the power to the central government to inspect at any time if any pending patent application or specification is related to such activities, and if it is found, the central government can also give directions to the controller of patents and designs. Likewise, the controller too has the power to refer an application to the central government to get the directions if they feel that it is related to atomic energy. And in such cases, the decision of central government is final. These are some important basics necessary to understand in patent. We shall see the registration, violation and remedies along with the case laws in the upcoming videos. Thank you.